Hello and welcome to another podcast episode brought to you by CLES. Now, before we dive into this podcast, I'd like to just say a few words about what CLES and CDPP is. So, the Center for Development Policy and Practice is a research organization which is based out of Hyderabad. We look into economics and public policy, but from the perspective of the development of marginalized and vulnerable communities. CLES, which is the Center for Law, Economics and Society, looks at the evolving legal landscape in India. Today we have Mohammed Aymen, who is a professor from Nalsar University. Currently, sir teaches election law, administrative law, and federalism to undergrad and postgrad students. The topic of today's discussion will be on the myths and misconceptions regarding the Constitution. Thank you for joining us, sir, today. Would you like to add anything? Yes, sir. Would you like to add anything to your introduction?
No, that's all.
That's okay. Great, sir. So we just straight away go on to some of the common myths that you have seen with the Constitution, sir. So what are the ones that you come across in your everyday life, not just from students, but also from people that you interact with, maybe at the policy level as well?
I think the most common myth that I have come across is the fact that I think it's WhatsApp, but also just generally that the Constitution is supposed to expire in 75 years is something that I was not aware of. Similarly, there is a similar myth that one has mocked online, but it still comes across that our independence is reversible somehow, that the British can undo it. It's not the most common one, but it's also the funniest one in my opinion. And it's simply not true, because the moment the Independence of India Act was passed by the British Parliament, the choice was left to the Indian people to decide what to do with it. And the Indian people, unlike Pakistan, did not choose the dominion status, which is part of the empire. Instead, India chose to be a republic. That was one of the first choices that the Indian Constituent Assembly made. And that basically severs our relationship with the British Crown completely. From that day onwards, the British have no power over us. It's a ridiculous idea to believe. But I think it is partially just, what we are going to probably discuss a little more, but it's a result of a resentment towards the Constitution, and that comes out across as, it comes across in these myths and these lies about the Constitution that it's not a permanent document. The truth is that it is not a religious text. It is not a Purana or a Quran or a Bible. It is a living document. So, and a living document changes with time, and the Constitution has that flexibility in it. Yeah.
So with flexibility, we also have studied, that our Constitution has taken bits and pieces from a lot of other constitutions as well. But then to come up and, say that, and to say that it's a totally copied material, what do you have to say on that?
I think it is true, and we must, this was something that was raised in the Constituent Assembly also. And Ambedkar said that there's nothing wrong in borrowing. There is no patent right. That's the word that he used. But as I understand it, why would you not look at the working of other experiences? Why would you not learn from it, and why would you not incorporate it? It was not blind copying. That is something that Indian academics are used to maybe doing, that, but it's not like our Constituent Assembly had a lot of lawyers, and a lot of them were trained in the common law system. They had practiced abroad, or they practiced in India. They were familiar with what should go into a constitution. And so there was no question that there was a lot of parts that were borrowed, but they were not borrowed blindly. They were done very well, and it was a pick and choose sort of a scenario, that Indians knew that this is going to work well for us and this is not, and that's why we're going to pick up something.
Okay. Yeah. So now talking once again about something that we have studied is that Indira Gandhi had inserted a couple of secularism and socialism concept in our Constitution. But again, there's a WhatsApp thing, or a misconception that no, it is not in our actual Constitution. So yes, how do you?
I think a way to address this would be to also address the criticism that comes from the borrowing accusation, which is that like two recent academic works, if one can call it that, have basically said that the constitution is colonial in nature, and so secularism, socialism are also foreign ideas. I think it is very important to understand where this criticism is coming from. The truth is that our constitution, even if it's borrowed, even if it inherited the Government of India Act 1935 to a great extent, it is not colonial for the simple reason that no one else is telling us what to do. The logic of colonialism was that the British crown had supremacy and suzerainty over us. The constitution replaces that sovereignty with the sovereignty of the people. And it's an idea, we can talk about it as an academic or an abstract idea, but the real implication of popular sovereignty was that no one else has a right to rule over us. And that by itself makes it a decolonial idea. Like it is not colonial anymore because it's saying that no one else can make laws for us. It is because of popular sovereignty that we don't have princes and kings anymore. We are in Hyderabad where there was a princely ruler once. It was self-government that prevented, it was the idea of popular sovereignty that took away the legitimacy of such kings. It was also popular sovereignty that challenged the idea that there is an aristocracy or zamindari that can rule over us. And so that is why we are not colonial. A secondary idea is that it is said that these were ideas that were copied, or like ideas like secularism, socialism, or even for that matter tolerance and dignity. These were Western ideas that were imbibed by our westernized leaders like Nehru, Patel, etc., and they had no place in India. I think the most important thing for us to keep in mind is that sure, these were foreign ideas. They did not come up in India organically. And yes, a lot of our leaders, including Nehru and Ambedkar, were trained in Western theory. But at no point did they just copy and paste those ideas in India. They took the concept of self-government or popular sovereignty and they used it to challenge the British. They adjusted its logic and they adjusted its meanings to India. So let's look at what secularism and socialism are, right? And it's true that Indira Gandhi incorporated it, but in the Constituent Assembly on the question of secularism, Ambedkar said that we don't have to add it to the preamble because it is part of the Constitution. Not everything that is part of the Constitution has to be part of the preamble. Socialism, when it was challenged before the court, so there are a whole set of judgments that deal with these questions, and the court said that this does not mean communism or state socialism. Socialism basically means that we change the existing state of affairs. So a difference in, like wealth inequality, questions of control of land and material resources. Socialism here meant a more equal and a more just society. Secularism also was imported from abroad, absolutely. But it does not mean the same thing that it does in Western countries. In Western countries, secularism means that the state and the church are separate. The state cannot participate in religious affairs and the church cannot control the state. That's the broad idea. In India, it basically means two things. One is equal celebration of all religions or equal treatment of all religions. And secondly, that the state will ensure neutrality in terms of religious affairs. So, if we were to incorporate the Western idea of secularism in India, you would have a situation where the state could not, say, reform temples and religious places and allow untouchables to enter those communities. If we followed that kind of secularism, then the question of endowments or waqf would not be something that the state could deal with. It would be left completely to religious communities. So we have freedom of religion, but it is significantly restricted and it is an Indian meaning of secularism.
Secularism.
At every stage, wherever we adopted, where we borrowed, these things remained, they were revised to apply it to the Indian context. They don't mean the same things that they meant abroad. And as far as the amendment to incorporate those in the preamble is concerned, it makes no difference because both of these principles are part of the Constitution.
Okay.
Whether they are part of the preamble or not, it makes it's the amendment basically expressed something that was unsaid or unspoken. Just one example before I conclude this question is the whole business of secularism. Let's say that it's not part of the preamble. You still have Article 14 that says that there has to be equal protection of laws and equal treatment.
Yes.
You have Article 15 that prohibits discrimination on the basis of religion. You have 25, 26, 27, 28, 29, which in some way or the other are dealing with the question of freedom of religion and to what extent that freedom should be extended to you. Just looking at these provisions alone, you will know that there is secularism. The fact that it's not reflected in the explicit text makes a very it's like that amendment basically said that this is already there, we are just expressing it in words. So that does not delegitimize it in any way, in my opinion.
So when we talk about tolerance and also understanding that India is a very diverse country, we understand that there are certain minority communities that also exist, of course the Muslims. So there is a misconception that Muslims are given extra privileges or extra constitutional rights like the Waqf. So how do we address this question?
I would say that let's look at the constitutional scheme. The Constitution only gives one specific right to minorities, and that right is also not only for religious minorities. It is for both majority and minorities, and that is the right of minorities to establish and administer their own educational institutions. The idea behind giving religious and linguistic minorities this right is that if you are a minority community, you can't continue your religious or tradition or language in any significant way if you can't run your own educational institutions. If you want to pass on whatever is relevant for you, whether it's your religious knowledge or it's your language and script, you need a systematic method by which you're transferring it to the next generation. You want to train teachers who are able to do that. The second way for us to think about it is this, that apart from your minority educational institutions, every institution is basically a majority educational institution. In most higher educational institutions, for example, Muslims and minorities they don't even keep up with the proportion of population. This means that you are basically like, it's not a special privilege, it is a safeguard against, saying that you at least have this, that you can run your own educational institutions. This is the only right that religious and linguistic minorities have specifically. Now, who counts as a linguistic minority? Every Hindu who is not in their home state, where their language is official, is a linguistic minority. So if you are a Bengali, for example, living in a Telugu majority state, you are a linguistic minority. You have a right to set up your own linguistic and you have your right to set up your educational institutions. If you are a non-Muslim living in Jammu and Kashmir, you should ideally have those rights, but there is some complexity on the question of who counts as a minority. Currently, a religious minority is at a national level. Nonetheless, the idea behind it is very simple, that a religious minority needs this protection for the simple reason that otherwise you would be forced to assimilate. You would lose your culture and tradition and language if you don't have this protection. And for example, in Telangana, you have Hindi speakers like the Yadav community who have been here for 400 years, but they are Hindi speakers. And they have their own educational institutions. You have Marwadis in many states that run their own educational institutions, as do Sindhis. Narsi Munji, I think, is a Sindhi-run institution, right? Now, this is one aspect of it. every other right is available to minorities and majority in the same way. So you can look at Article 29, which is an absolute right. It is a right to conserve your script and culture and language, which is available to any section of the population. Majority or minority, doesn't matter. Now, this is a protection that is afforded to everyone. Similarly, whether it's Waqf, let's look at Waqf as well. That since you've mentioned it, I'll just take one moment. That Article 26 deals with Waqf. Article 26 again is not about minority rights. It says that if you are a religious denomination, you have a right to establish and administer your own charitable and public institutions, which includes endowments. The law on Waqf is a central law. But almost every single state has a law for Hindu endowments. And these laws are identical because they were developed during the British era. And they are the same thing. So if the criticism is that there is Waqf by user in Waqf, you have the exact same thing in endowment laws, where courts say that you don't need a document to prove that this is an endowment. If it is used as an endowment or a temple for a very long time, it will be treated as a temple. So this is basically that do Muslims or minorities get extra protections? One has to see it within the constitutional scheme, not significantly. But let's also look at international human rights, where it is accepted that the majority, since the majority is not afraid of losing its tradition or culture, the majority is not afraid of being dominated by another group, or that it's not, any of the anxieties that minorities have, they do need some special protections, especially in terms of language and culture. That's the only explanation that I have for it. Yeah.
So in terms of religious identity, there's also the caste identity that we carry, right? So there is this another myth that reservation has an expiry date, as in the like the statute of reservation, as well as that reservation cannot be given on religious grounds.
Right.
So how would you like to address to that?
Firstly, the 10-year myth, unfortunately, it has captured our minds in a way that nothing else has. So much so that a former High Court judge who's currently a Supreme Court judge and is going to become a Chief Justice said it in an unconnected judgment that reservations were only meant for 10 years and reservations are the reason why the country is backward. Now, that is an empirical thing that judges cannot anyway assess. But let's look at this 10-year business, right? In the Constitution, there is Article 334, which deals with political reservations for scheduled castes and scheduled tribes. This political reservation says that a percentage of your seats in Parliament and Legislative Assembly should be reserved for scheduled castes and scheduled tribes. This reservation is meant to ensure that there is some representation for those communities that were completely excluded from political power. The absence of reservations would basically mean complete domination of lower castes by upper castes. So that was the reason why. It is in 334 that there is a 10-year period that is extendable by Parliament before the expiry of 10 years. It is a process, it's a democratic process, it's not like scheduled castes have a veto over it. Parliament passes a resolution or an amendment saying that we will continue this beyond for the next 10 years. And then assemblies have to pass, legislative assemblies have to pass a resolution saying that we agree with this amendment. So firstly, it's not like a veto in any sense, but this 10-year reservation principle does not apply to educational institutions or public employment. The question, when it was raised in Parliament, in the Constituent Assembly, Ambedkar clearly said that this should not exist. This 10-year period should not exist. The test is that if there is substantive equality, reservations will stop meaning anything. Once you have, reservations have they've delivered the goal, people will themselves withdraw from the list. They wouldn't need it. So that hasn't been achieved. Even to this day, forget education and employment. Even to this day, getting elected as a scheduled caste person on a general seat is very difficult. The way delimitation has happened, for example, it means that scheduled castes don't have seats reserved in places where they don't have significant numbers. So substantively, it hasn't been achieved. So therefore, the 10-year period doesn't make sense. Now, on the question of religion and reservations, it's absolutely correct that you cannot give reservations solely on the basis of religion. So you should not get reservations in employment, education, or politically just because you are a Muslim. But reservations must be given on the basis of backwardness, social and educational backwardness. That is a empirical fact. It is not a perception. And in this case, wherever Muslims do get reservations, wherever Christians get reservations, it's not because they are Christians or Muslims. They are getting reservations because they are backward Muslims or backward Christians. And in many places, they have a subclassification, like in Telangana, where Muslim backward classes are treated as a separate category.
Okay.
And this is a problem for many people because they call it Muslim reservation, but that category is that it lists out castes that are backward among Muslims who get reservations. The idea behind subclassification is that if you just have one single quota, a numerically dominant group will take all of that quota. So there is I'm not sure, I don't remember the Judicial Commission's name, but there was a very recent commission that was set up by this government that itself said that the OBC quota is dominated by a few communities and a whole percentage is taken up by them. So the idea behind subclassification is that you reduce the possibility of a single caste or a group taking over everything else. Now, there is one and only one religion-based quota in India. And that religion-based quota is the 1950 presidential order. The 1950 presidential order says that if you are a scheduled caste, you cannot be Christian or Muslim. The order basically says that you have to be Buddhist, Sikh, Hindu, or Buddhist, Sikh, and Hindu, if I'm not wrong. And these are the only religions that a scheduled caste person can belong to. This is the only religion-based quota. It excludes Muslims who come from untouchable castes, like the halal core community. And moreover, it limits the freedom of religion of scheduled castes from converting from their religion of birth. And this is the only religion-based quota. So people, if they're opposed to a religion-based quota, they should be opposed to the 1950 presidential order.
So what we are also seeing, especially in our neighboring state, is the debate around the language as well. So in terms of language, it is believed that Hindi is our official constitutional language. Is that so?
Hindi is not our national language, which is the common misconception. Hindi does enjoy a privileged status in India as an official language or an official language that should be the sole language. And I think this is one of those places where our constitution can be critiqued, but one can also understand that it was done by a generation of people who had seen Europe as they looked and wondered what would it take to be a nation state, and they thought that a common language is essential to bind people together. So it was from that perspective that Hindi enjoys a certain degree of privilege, and however, it is simply not true. Indians continue to be, we speak in our own languages, but we remain Indians. In fact, our unity and integrity is only strengthened despite the fact that we made linguistic states, and despite the fact that we have many states with official languages that are not Hindi.
Yes.
Right? That hasn't harmed national unity in any way. It comes from a different legacy where it was believed that you need a common language. In fact, now, because of advances in technology, you don't even need translators to translate between languages. What would What we do need is the state encouraging Hindi speakers to learn other languages, just as it encourages non-Hindi speakers to learn their languages. So also, like, we have to think about the fact that we have about 20 odd official, like we have 20 odd nationally recognized languages in the constitution. That includes Telugu and a whole bunch of languages, including Urdu, Sindhi, Sanskrit. But we also have many more languages which are treated as dialects.
Yes.
So if you are from the so-called Hindi belt, there is, I was very surprised to know that the largest viewership of any TV channel is Bhojpuri.
Yes.
And Bhojpuri, forget having a state of their own, Bhojpuri speakers, their language is not even recognized as a language, it's recognized as a dialect of Hindi. There are millions of speakers, including Marwari and Magadhi and a whole bunch of languages that are not recognized as languages at all. And making Hindi an official language erases our diversity in terms of our languages and how different our languages are. So yes, it's true that it is an official language in some ways, but it's not necessarily, it doesn't have to be, is what I would say.
Sir, we talk about a lot of the myths and the misconceptions, but one would like to understand that why does these misconceptions persist to exist in our day and age, and what are the factors because of which they are still here in different conversations?
I think this requires us to understand, like, I don't think these are myths that exist because of mistaken information. Like, I don't think these are innocent mistakes. I think they are based on a resentment towards the Constitution. And this resentment is not new, it has existed even before the Constitution was drafted. And if we were to think about it like that, then the resentment is because the Constitution is not just saying that we should have a government, a democratic government, or that there should be a right to vote and things like that. It's primarily to do with the fact that the Constitution says that there cannot be a dominant group. There cannot be domination. And this means basically that if you are rich, it doesn't matter. If you are a majority, it doesn't matter. If you are a powerful minority, it doesn't matter. There is an inherent equality in the theme of the Constitution, that each person is of equal value. This is not acceptable. So the criticism that this is not acceptable for many groups that enjoy power, and resentment stems from that. So if you see, like, the myths that we've discussed, whether it's secularism, reservations, these are primarily because the Constitution said that there has to be a remedy available to people who are completely weak. There is some measure of protection for people who are vulnerable. And that is why these myths persist. That is where this resentment comes from. I think this resentment got stronger because of where we are right now in India, right? Like, I think there are a lot of frustrations about how the government functions, the fact that our judiciary is not effective, there's a lot of pendency, it's too expensive to go to courts. Politics is not accessible for common people. So it's not possible for people to, or it's not okay for people to blame the people running the Constitution. It's easier to blame a non-living thing, right? And that's why it's easier to blame the Constitution rather than saying that, the people running it are not okay. And that's what Ambedkar had warned when the Constitution was being adopted, that no matter how good a Constitution is, if the people who are called to work it are not good, then it's not going to be a good Constitution. And I think that that's what it is. That's why these myths persist.
So, sir, do you think this is very unique to the Indian Constitution, or are there other countries who face similar misunderstandings?
I think most countries do. I am not I'm not a scholar in on other constitutions or in other politics, but as I understand it, the reason why so many global south countries do not have a very effective, like there are frequent changes, regime changes, there are coups, is primarily because the constitution did not have a connect with the society. It was a constitution that was imported from abroad without any application to the context. So these myths exist everywhere. Where they don't, it's primarily because people have a lot more access to education and they understand the value of the constitution. So as I would think, I would imagine that even the American Constitution, which is the longest running written constitution, if I'm not wrong, the longest one in force. I think the answer that people have is, if it's not this constitution, then what? And that answer is horrifying for people living in democracies, right? Like the idea that I will not have the right to vote or to question my government is a scary thought. And so even if it's not a perfect constitution, it is good enough for a country to run. So that is, I think, that's why we see it in some countries and we don't see it in others.
Okay, sir. So, sir, our concluding question, I think even the audience would love to know, is that are there any prevention mechanisms that can take place to fight the misunderstanding, the misinformation, and how do we rebuild the trust in our constitution, irrespective whether you're an educator, a scholar, or even an 8th grader where we're introduced to the subject, right? How do we fight this?
I think it's something even I struggle with, but I think one reason why there's such a disconnect between the constitution and the people in whose name the constitution runs is because the average citizen thinks of the constitution as a legal document. It is not a legal document in that sense. It has to be reimagined or correctly imagined as a document of self-government. And self-government basically means that we are all sharing in the running of this country. The idea is that the constitution is facilitating our shared coexistence together and that we are all participating in it. I think the moment that happens, it is possible for us to then tell people who are not aware that this is not about who gets to be prime minister or how a chief justice is appointed. It's about your stake in the country, right? And therefore, like, I think that is the idealistic answer that I have. But the practical thing is for us to basically, as like I'm an educator in that sense, I teach. So for me, I think what is most valuable is that we take out the constitution from the hands of lawyers. Lawyers and judges would think of the constitution only as a text that needs to be interpreted in a very narrow sense. But for common citizens, the constitution's value isn't the fact that it wants to transform the social situation. That's the vision of the constitution. And for that to happen, I think more than anything else, it is about educators and scholars making that the constitution accessible as a text. And that means it's also not just taking it out of lawyers' hands, but it is also to take it out of English and to do it in languages that are more understandable to us. The Ambedkarite movement has done it for all these years fairly well, very successfully. But for the elites and for middle classes, it's easier to believe the myths than to actually read the text. That's the challenge.
Challenge that we have. Thank you so much, sir. I think this was one of the most insightful discussion we have had, and we can only hope that this discussion leads to more informative debates and conversations in the future. Thank you so much, sir.
Thank you. Thank you.